Recording in progress.
Hello everyone, good afternoon and good evening. I'm here again in this 17th edition of the International Law Winter Program of CEGIM. In this morning, we've heard Professor Ian Kong of the Manchester University. It was a very interesting lecture about rule of law and the WTO law. Now we're back again with Sir Michael Wood, and I'm extremely grateful to host him for the second time. My name is Maria de Lourdes Albertini. I'm a professor of international law at Catholic University of Minas Gerais, Brazil, and at CEGIM. Sir Michael Wood, before you take the floor, let me briefly introduce you to our academics. Sir Michael is a member of the United Nations International Law Commission. He spent 3 years at the UK mission to the United Nations in New York, dealing chiefly with Security Council matters. Sir Michael Wood is a barrister at the 20th Access Chambers. He was legal advisor to the Foreign and Commonwealth Office between 1999 and 2006. After joining the IFCO in 1970, he attended many international conferences, including most sections of the Third United Nations Conference on the Law of the Sea, the Lancaster House Conference on Rhodesia, the 2+4 negotiations on German unification, the Cambodia Peace Conference at Paris, and the Dayton and Humboldt conferences on the former Yugoslavia. His posts include 3 years at the British Embassy in Bonn and 3 years at the United Kingdom Mission to the United Nations in New York, as I said before. He was agent for the United Kingdom for a number of years before the European Commission and Court of Human Rights, and was agent in the Lockerbie and legality of use of forces cases before the International Court of Justice, as well as the Sellafield proceedings before the International Tribunal for the Law of the Sea, and 2 international arbitral tribunals. CISLINVI, the FCO, Sir Michael has appeared on behalf of various states in proceedings before the International Court of Justice, the International Criminal Court, the International Tribunal for the Law of the Sea, and the Interstate Arbitral Tribunals. Sir Michael Wood, very happy to have you here again, and I'm absolutely sure that we will have a unique opportunity to learn more about the general principles of law as a source of international law. Please, now the floor is yours.
Well, thank you very much, Professor, for that very kind words of introduction. I'm very grateful to be invited for a second time to be part of the winter program, so I can't have been too bad the first time, which is comforting. The subject, as you said, is general principles of law as a source of international law. As you've explained, I'm very much a practitioner and have never been a professor, though occasionally I do give lectures. So it's interesting perhaps that I've picked what might seem a rather theoretical subject. General principles of law don't come up very often. They're quite mysterious, and it's a subject on which academic writers have written quite a lot, including Professor Pele, who you heard earlier in the week. In fact, Pele's doctoral thesis was on precisely this subject of general principles of law. It's never been published, but it's available online and is a very good and interesting read. So the reason why I've chosen this subject is partly because we're discussing it at present in the International Law Commission, but mainly because I think it's a very good illustration of the importance of clarity in international law, particularly as regards the sources of international law. practitioners tend to like clarity. Judges ought to like clarity. Sometimes it's suggested that clarity is a bad thing, and that it's good to be able to be vague, to be flexible, to be able to develop the law by using vague terms. And this is something that some academics, but I'm sure not any of those present here, seem to think is a rather good thing. To take an example, well, to look at the main sources of international law, treaties, first, are pretty clear. We know what they are, we know when they're in force, but even there, you get soft instruments, people saying that something that looks like a treaty but isn't a treaty might have the same effects or have some legal effects. So even with treaties, there's vagueness. And then we come to the second principal source of customary international law. There, as we all know, it's again quite mysterious. It's possible to come up with all kinds of arguments about it. But the International Law Commission, 3 years ago, adopted conclusions on the subject of customary international law, which try to spell out, with some degree of precision, though leaving some flexibility, how to identify the rules of customary international law. And certainly the English courts have found what the International Law Commission did helpful and have quoted it. There are others I've heard saying it's too rigid. Customary international law is inherently flexible. You can't lay down any real guidance on the subject. You're trying to make it too difficult to find rules of customary international law. But I don't agree with that. But the most difficult of the three sources set out in the statute of the court is undoubtedly general principles of law. And that's why I thought it would be an interesting subject to discuss this evening. Part of the problem with international law generally, but with general principles of law in particular, is terminology. Because people use words with almost any meaning. It's a bit like Alice in Wonderland sometimes. And indeed, we often cite Alice in Wonderland at the International Court of Justice when we think the other side is inventing special meanings for words. But terminology is a really big problem in international law. Clarity of terminology, I think, is very important, and particularly with general principles of law, as I will explain. I might say that I plan to talk for about 45 minutes, 50 minutes, and I very much hope that then we can have questions, because I would much rather answer questions than just talk. Now, to begin with the terminology, firstly, general principles of law recognized by civilized nations is the exact wording of Article 38, paragraph 1c, as you all know. But it reminds us of that expression, general international law. Now, I always question references to general international law. What does the International Court mean when it says general international law? Sometimes in the same sentence as customary international law. Is it just another word for customary international law? Or are they being deliberately ambiguous as to whether they're talking about customary international law or widely ratified treaties or even general principles of law? So I always say we should avoid using the term general international law. However, when I'm counsel before a court, I sometimes find it very convenient to use that term because it's a term that the judges seem to like sometimes. I once asked an ICJ judge why they use the term general international law instead of customary international law. And he said, well, it's good just to use a different expression from time to time. It would be boring if we just use the same term. That seem to me to be a very inadequate and poor answer. Another problem with general principles of law is that so many different terms are used for them. In particular, we often see references to general principles of international law. And people writing about Article 38(1)(c) talk about general principles of international law, which is not, of course, the language of Article 38(1)(c). And then they try to bring in to that source of law all kinds of general principles of international law, such as the principles in the Charter, or principles such as the need to consent to the jurisdiction of a court, all kinds of things that they say are general principles of international law, but they try to get away from customary international law, away from treaties, and put them into this heading of general principles of law. Now, another problem, which was caused almost entirely by Alain Pellet and French writers, is that in English it says general principles of law. And in French, the statute says principes généraux de droit, not du droit, but de droit. And in Spanish also, it's principios generales de derecho, not del derecho. Now, you might think, and I think, this makes no difference at all, du or de or del. But according to some French authors, it makes a big difference. And the fact that Article 38 says principes généraux de droit means you cannot look at principles of law other than those derived from the national legal systems. So they would exclude any second category of general principles of law. I think that's wrong, but it is leading in the Commission to people trying to change the text of the statute in French and in Spanish. And indeed, the translators of our documents have mixed it up. They often mix up the translation. The UN Secretariat have written a very interesting paper a year or two ago in which they say that terminology is the big problem with this topic. And they refer to terms such as principle, general principle of law, general principle of international law, principle of international law, all being used interchangeably in the literature, but also by courts. So that makes it very, very difficult when you look at a judgment of a court, or you look at a treaty, or you look at writers even, to be at all clear whether they're talking about this third source of international law, general principles of law, or whether they're talking about something else. Now, one thing that we'll try to do is clarify the terminology. And the International Law Commission is usually rather good at clarifying the terminology. If you look at state responsibility, the language, the terms that it's used, like countermeasures, circumstances precluding wrongfulness, these have all entered the language of international law and become standard and understood. And I hope that also in the field of sources, we shall be able to do something similar. I'll just say a few words about Article 38, paragraph 1 of the ICJ statute, which you all know very well, and as you know, which follows very closely Article 38, paragraphs 1 to 4 of the Statute of the Permanent Court of International Justice, and which dates from 1920. The only change is in the chapeau, where there was a Chilean amendment in 1945, which includes the words, the International Court, whose function is to decide cases in accordance with international law, which helpfully clarifies that what follows are the sources of international law. I think that the 38 of the statute is widely accepted as a basic statement, at least among practitioners, of the sources of international law. Its importance goes well beyond the ICJ. It's referred to in many treaties, and most international courts and tribunals accept it as a basic statement of the rules of international law. A third basic point is that there are only three sources of international law listed: treaties, custom, and general principles of law, because the fourth line, paragraph D, are subsidiary means, moyens auxiliaires in French, which is a good phrase, and I think it's similar in Spanish, medio auxiliar. I don't know what it is in Portuguese, but in any event, as we know,
subsidiario.
Right. These are subsidiary means in English. They are useful to assist us in determining what the rules are under the three sources, but they're not themselves sources. Having said that, they are, of course, in practice very important, and perhaps particularly in relation to general principles of law, as we'll see. One question that I'll perhaps come to at the end is the relationship between these three sources of law, and particularly the relationship between general principles of law and customary international law. Because there is a danger if we take too relaxed a view of what are general principles of law, that we'll end up with what Professor Klaber's called custom light. You can come up with rules that look like custom just by referring to general principles of law, and you don't have to look for practice, you don't have to look for opinio juris, etc. If we look at, start with writings on the subject, which is frankly where we all look when there's a new subject or a subject that is obscure, to see if we can find anything useful. And then we look at case law. I don't think there's much that is useful in writings on general principles of law. In the past, Hirsch Lauterpacht said quite a lot about it, and there's always his thoughts are very worthwhile. And then we have the classic volume, at least for English speakers, in 1953 by Professor Bin Cheng, who was from China, or his family was from China, but he was the professor at University College London, and who wrote this very great book in 1953 on general principles of law. Bin Cheng sadly passed away 2 years ago at the age of 98. That's the other day of international justice. He was the last, or perhaps the only Chinese judge on the Permanent Court of International Justice. But apart from Lauterpacht and Bin Cheng, there's relatively little. I've already mentioned Professor Pellé's 1974 doctoral thesis, which is well worth reading. You can get it online, it's typewritten, it never came out as a book. But his basic thesis is that it is only principles derived from national legal systems that come within the statute of the court under the heading General Principles of Law. There's also Pellé's commentary from 2019 in the commentary by Zimmerman on the Statute of the International Court of Justice. He's written a commentary on Article 38 together with Daniel Müller, and that commentary is really a very good introduction to the sources of international law with quite a few pages on general principles of law. So that's where I would look for writings. If you look at the standard textbooks, they deal with the subject very briefly and really not very satisfactorily. There's very little written. It's so difficult. They don't try to deal with it in most standard textbooks. The books on the sources of law, of course, do deal with it to some degree. The very good short book by Hugh Thirlway, the second edition of which came out in 2019, has a good chapter on the subject. But that's about it, really, at least in English. Then there are some writers who've written quite extensively on the subject, articles, a couple of books in the last year or two. I find them very confusing. They tend to suffer from this terminological confusion I mentioned at the beginning, and they seem to regard any general principle of international law or principle of international law as coming within the source that the statute calls general principles of law recognized by civilized nations. Now, two very good sources just in the last year are documents of the International Law Commission, because once we take up a subject, we tend to produce some very useful and very practical documents. And I would strongly recommend the Secretariat Memorandum from 2020, which sets out all the practice they could find in treaties, in court cases, elsewhere on the subject of general principles of law. It's a very good resource. And similarly, the special rapporteur who we've appointed has written two good reports that are full of useful information. The special rapporteur, by the way, is Ambassador Marcelo Vázquez Bermúdez from Ecuador, who really has done excellent work in the subject. He's a very good member of the Commission, in my view. I just mentioned a word of warning about documentation, though, of the International Law Commission. Writers often refer to these documents and say the International Law Commission has said this or has said that, when they're really quoting a report by a special rapporteur or the memorandum of the Secretariat or a first draft by the Commission or the work of the drafting committee. And they don't look to see if this really reflects the views of the International Law Commission. So I'm thinking that we need to put a word of warning on all our documentation, saying that it doesn't necessarily represent the views of the Commission. At least that needs to be made clearer, I think. But I know you're going to have a talk next week, I think, on the International Law Commission generally, by Professor Patricia Galvez-Tales from Portugal, who's here in Geneva with me, and I'm sure she will say a lot more about the Commission, so I'll try not to. To go back to the drafting of the statute, the Permanent Court of International Justice, that came up with this formula, general principles of law recognized by civilized nations. You've probably all read a bit about the drafting of it, but it's very difficult to find in the travaux préparatoires any clear indication as to what this source of law covers. At one point, the British member of the committee that wrote the statute or drafted it said, this is to cover principles taken from domestic law in foro domestico. But there wasn't any general agreement on that necessarily, so you can't take that as the last word. People do try to argue from the travaux préparatoires of the statute, but it's not very convincing. Indeed, in my view, it's almost always not very convincing to argue based on travaux préparatoires. They're almost always partial for any agreement, any treaty, and you can usually argue every point of view based on travaux préparatoires, and that's true to some extent here. The reason why general principles of law were added to treaties and custom, I think, is relatively clear. They wanted to avoid gaps, to avoid a non-liquet. So perhaps general principles of law can be used to fill gaps where international law, treaties and custom don't provide a rule. On the other hand, that's quite a dangerous point of view because, as we know, there's no reason that states necessarily want to provide rules for everything. The Lotus principle is much maligned, but it's still good law, in my view, that states are bound by what they've agreed to, essentially. And they don't necessarily want to have rules of international law on everything. So this notion of gap filling or non-liquet, avoiding a non-liquet, is slightly dubious, but I think it was the reason why those expert men, and they were all men, in 1920 drafted the charter in the way they did. I won't say anything about the way the ILC operates, but just to indicate where we've got with this topic, it was taken up in 2017 onto a long-term program of work with a syllabus prepared by Marcelo Vázquez Bermúdez. So that's the starting point. And that syllabus is in the ILC's report for 2017. Then in 2018, we decided to put the topic on our actual agenda, our current program of work, and we appointed Vázquez Bermúdez as the special rapporteur. So he then produced a first report in 2019, which we debated. It was, I think, a very good preliminary report. And then last year he produced a second report, which is more difficult or controversial because it's getting into the difficult issues. And we couldn't debate it last year because we didn't meet last year because of the pandemic. So we debated it for the first time this year. We are meeting this year, but in a hybrid form. So some of us are in Geneva, some of us are in their homes. And that makes for a very difficult process. It works, we can do things, but it's extremely difficult, as perhaps Patricia will explain, because of, for no other reason than time differences. It's 16 hours time difference between different members of the Commission. It's also difficult because of internet access, which doesn't work in all countries. So above all, it's difficult because you don't have the personal touch that you have when you're all in the same room. You're able to discuss things informally. You just can't do that when you're doing it online. So the sooner we can all meet together, the better. But it is the case that there's about 25 of us here in Geneva now, including Ambassador Saboya, the Brazilian member who came for this July half. He was not able to come in May, but he's come for the July half. He participated fully in May from Rio, I think, which is where he lives now. So it's working. And we're in the middle of our debate on the second report. So we all make speeches about what we think about the second report. In fact, I made my speech this morning, so I'll try not to repeat what I said then. But there's been some very high quality interventions already. I think Professor Dirk Tladi from South Africa on Monday or Tuesday made an excellent statement, as did Matthias Forteau, who was re-elected to the Commission in May. after Georg Nolte left to go to the International Court of Justice. The Commission then has a by-election, and we elected Matthias Forteau. And of course, he gave a very thoughtful intervention, as have others. The key issue, as I'm sure you all know, is whether there is one or two categories of general principles of law. It's widely accepted, generally accepted, that there is a category of general principles of law that are derived from national legal systems. You take something like estoppel or any Latin phrase that comes up in national law, and you say this also can be applied in international law. So things like res judicata and the like, courts have derived them from national legal systems. But then the real question is there a second category or even series of categories of general principles of law that are formed within the international legal system or derived from the international legal system? Can you come up with general principles of law that are inherent in the international legal system? It's often said that you can, and the Special Rapporteur, Vasquez Bermudez, seems to be clearly of the view that there is a second category. But there are divided views on that. It's controversial within the Commission. There's divided views within states. When they debated our work in 2019, views were very divided. Personally, I'm a bit skeptical, but on the other hand, I do think it's useful to explore whether there are such rules, principles that can be derived from the international legal system that are inherent in the international legal system. I mean, one such rule, just to give an example, that's cited is the need for consent to judicial decisions. You need to consent to the jurisdiction of a court. That's said to be inherent in the international legal system, but I don't think that means anything really, because under international law, obviously you can't be taken to a court unless you've agreed to the jurisdiction of the court. And you might agree ad hoc or through an optional clause with the ICJ. You might agree generally, as with the law of the Sea Convention, where you've agreed to a very wide range of compulsory jurisdiction. But that doesn't really, there's no principle of consent that is derived from the inherent nature of the international legal system, in my view. But it's quite interesting to see how the Special Rapporteur is trying to explain these things. And his draft conclusions are very brief, so I might just refer to them as we go through. Firstly, he has 3 draft conclusions on general principles of law derived from national legal systems. And I don't have big problems with what he's saying there, though even there, he adds some conditions. He says it's got to be quite stringent, which I agree with. And then he comes up with conditions which I don't really agree with. The first condition, he says, is that a principle has to be common to the principal legal systems of the world. That we all agree with. How common, how wide and representative, whether it has to be in all legal families, whatever they are, and all regions of the world. It's a bit like customary international law. We're going to have to come up with good language there that's flexible as well, I think. But then he says it has to be transposable, or it has to be transposed even to international law. How do you decide what's transposable or what has been transposed. Well, the key language in the statute is that it has to be recognized by civilized nations. General principles of law have to be recognized by civilized nations. I'll come back to civilized nations in a moment, which is a very embarrassing expression, as we know. But so recognition, it has to be recognized that something is transposable or transposed. So it has to, let's say, work under international law. So, for example, if you take traffic regulations, in most countries, I don't know about in Brazil, but in most countries, you have to drive on one side of the road or the other. So this could be a general principle of law, but it makes no sense if you transpose it to international law. The way he's expressed it, he says it has to be compatible with fundamental principles of international law. Well, I disagree with that because I don't know what fundamental principles of international law are. So his efforts to be stringent are making me disagree. And then he says that the conditions have to exist for the adequate application of the rule principle in the international legal system. But what does adequate application mean? One of the courts, the International Criminal Courts, said we can't use this rule that we find in all national legal systems because it's too difficult for us to apply because we're an international criminal court and we don't understand it properly. That seems to me to be a very inadequate reason for not applying a basic rule of fair trial and unjustified in my view. So I dispute the question adequate. I think it has to be applicable in the international legal system, which road traffic is not, but it doesn't have to be adequately applied. You have to apply it, and courts will have to do their best. Just two points going back to where we've looked for guidance. The Special Rapporteur and the Secretariat have looked for guidance on general principles of law to international criminal courts and tribunals to a great degree because they are constantly referring to general principles. I think that's not very satisfactory because international criminal law is a very specialized field. Mostly they're looking at rules of procedure, of international criminal procedure. Very often the judges are not international lawyers. Almost always they're not giving judgment after hearing the views of states. They hear the views of prosecutors and of defenders, but not states. So there may be guidance, but I don't think we should rely on it too much from international criminal tribunals. Of course, there's not that much guidance from the International Court of Justice either, because they avoid the point or deal with it in a very obscure way. A second place where reference is made, where the Special Rapporteur and the Commission has looked for guidance, is in pleadings of states before the International Court of Justice and other international courts. And there are quite a few cases where states have argued for a general principle of law or argued against it. I myself argued for Timor-Leste for a general principle of international law that lawyers of legal professional privilege, that lawyers should not be interfered with because our own lawyers had their papers stolen by the Australian Security Service. Australia argued very strongly there was no such general principle of law for the purposes of international law, and it wouldn't work on the international legal level because it was very specialized, etc. And so those are quoted as examples. There are other ones. Nauru, I think, in the nuclear weapons case, argued strongly for general principles of law prohibiting nuclear weapons or leading to the prohibition of nuclear weapons. I would agree that pleadings of states can be interesting and they can be useful evidence, but I don't think we can rely too much on what states say in a case, because it's their lawyers who are saying it. They've hired lawyers to say whatever they can say to try and win that case. Of course, they are committed by what they've said. They should take it seriously, but they don't always. So I wouldn't pay too much attention to pleadings. But then that leaves us with rather little. Sorry, that was a bit of a diversion. And I'll come to really the key question before the Commission and before all of us who look at general principles of law. And that is whether there are general principles of law, as the Special Rapporteur puts it, formed within the international legal system. I don't like the word formed because it suggests to me some kind of spontaneous law that just forms itself and we can't do anything about it. And I don't like the idea of spontaneous law, though I appreciate there are some who do. But I would prefer to refer to it as general principles of law that are inherent in the international legal system. But that still doesn't get us very far in identifying them in some kind of rigorous way. And the Special Rapporteur has proposed three subcategories, if you like, of general principles of law from within the international legal system as opposed to from national legal systems. And the first he gives is a principle that is widely recognized in treaties and other international instruments. And he mentions General Assembly resolutions. Well, I don't think that can possibly be a sufficient basis for saying there's a general principle of law. If we say that principles are widely recognized in treaties, I mean, is that saying that all the principles in the law of the Sea Convention, which is widely recognized, which is widely accepted, are somehow general principles of law, so we don't have to worry about the treaty, we don't have to worry about customary international law, we can just say they're general principles of law because they're widely recognized in treaties, or widely recognized in General Assembly resolutions. So I'm very skeptical about that as a sufficient requirement, at least. Then his second category is even more dangerous, I think, and obscure. He says a principle that underlies general rules of conventional or customary international law. So he's looking at sort of mega or meta principles and engaging in some kind of a deductive exercise. I don't know what's meant by a principle that underlies a general rule of customary international law. Indeed, I don't know what a general rule of customary international law is. So I get completely lost with this category. He gives, by the way, examples of all these things, but I won't go into details. They're not convincing. For example, principle widely recognized in treaties, he comes up with the Nuremberg principles because they were widely recognized by a General Assembly resolution. But if anything, they're customary international law. They're not general principles of law. If they are, they're probably general principles of law derived from national legal systems, like superior orders, or not being convicted of a crime that wasn't a crime when you were when you committed it, or these sorts of things. So his examples are not very convincing. And then the third category he has, which is the one I get close to agreeing with, is a principle that is inherent in the basic features and fundamental requirements of the international legal system. Inherent in the basic features and fundamental requirements of the international legal system. Now, I totally disagree with the expressions basic features and fundamental requirements, because those are completely vague concepts. This expression and those concepts come from the Kuprikic decision of a trial chamber of the Yugoslav tribunal. That's the only place where I've seen them used. I would have accepted this more if it just said a principle inherent in the international legal system, without saying it has to be inherent in the basic features and fundamental requirements of the international legal system. But then it's perhaps not clear enough, it's not rigorous enough. It allows courts, because who's going to decide what is a general principle inherent or a principle inherent in the international legal system? Are we leaving that to judges? Is this judge-made law? Do we accept judge-made law in international law? Are states happy to have judges making the law? If the judge makes the law in a case between two states, are all states bound by that law? These are very difficult issues. So my conclusion is that I'm skeptical about this second category of principles derived from international law, as opposed to principles derived from national law, but I'm prepared to explore it. I think the notion of things being inherent in the legal system is a possible one, but I'd like to find better language, and if anyone here has ideas that makes it more rigorous, that makes it, there have to be reasons, there has to be argument that leads to a conclusion that something is a general principle that's inherent in the international legal system. So that's more or less where we are with the International Law Commission. It will go on for another 4 or 5 years. It's not going to be over very quickly. There'll be a new commission and I won't be on it. It'll be interesting to see what people think about it. So there's plenty of time for input from academic institutions and from others who think about these things. So I hope there will be efforts to take part in it. We did ask states for their views 2 years ago, and 4 states answered. This is even more disappointing than usual. The 4 states, we asked them, what is your practice? Give us examples. What do you think of it? Russia gave a very good answer. It's on the website. They gave about 20 pages where their constitutional court had explained about general principles of law as international law. So that was interesting. It may not be correct because Professor Tunkin had a very strange view of general principles of law. He thought it was really just the principles of the Charter, which don't really need to be general principles of law because they're in the Charter. But anyway, so Russia, Belarus didn't say very much. Australia sent in a lot, including in particular examples of their court pleadings, such as the Timor-Leste one. So that was quite useful. They've informed us of what they think. And the 4th state, I've forgotten who the 4th state was, which is very naughty of me because, it was the Netherlands. The Netherlands sent in some also quite interesting comments. But it's very bad when most states don't. So I would encourage Brazil to do so, for example. The Secretariat memorandum, however, that I mentioned, almost makes up for it because they've done such a thorough study of practice, treaty practice, court practice, etc. It doesn't do domestic courts, but they've done very good work on the international practice of states. So that makes up for it to some degree. Now, I'd better say a word about Civilized Nations, because in 1920, the term was used. So it says, the general principles of law. I think the word "the" is quite important, often forgotten. The general principles of law recognized, very important, by civilized nations. Now, in 1920, the term civilized nations was commonly used in international law. to suggest basically European nations and perhaps, Latin American countries, no doubt, but they're European really. I'm talking the 1920s, perhaps Japan, gradually one or two others. But it's a completely unacceptable term now, and it's generally the view that all states are civilized for these purposes. They all have legal systems. They're all to be taken into account. So the proposal from the Special Rapporteur is to say instead, recognized by the community of nations, which is a term used in the Human Rights Covenants, for example. The UN Human Rights Covenants use that expression instead of civilized nations. But I disagree with that term on two grounds. Firstly, can you hear me still all right? You're looking a bit puzzled. You can. Firstly, I don't like the word nations. Nations, of course, is commonly used. After all, it's the United Nations. But I don't know what the word nations means. I don't think it's a term of art in international law. The Americans tend to use it because when they say states, they get confused about their own states. But the term nations doesn't really seem to me to have much meaning in international law. Secondly, I think that whereas the term states is absolutely clear and accepted, except by some North Americans, the other word I don't like is the community of nations, because introducing the notion of the community of nations, where the statute just says recognized by civilized nations, it doesn't talk about a community, it's beginning to look, well, it's a different concept. Maybe it's the right concept. After all, we have the community of states in the Jus Cogens provisions of the Vienna Conventions, but it's not what Article 38 is referring to. So I would prefer a very simple term, something like recognized by states. And then we can discuss about how many states generally, it's obviously not all states, but it's most of them. One would have to talk about that, but I don't like the expression community of nations, which is what currently the Special Rapporteur is talking about. Mr. Tladi, who's very able, as I'm sure you know, he said the other day he likes nations because it's broader. We're not just talking about states. We might be talking about non-state actors. We may be talking about international organizations. We may be talking about whatever, which is another reason why I don't like it.
NGOs, people in general.
It gets worse. No, to be serious though, there is an issue in the report about international organizations. And I do agree with what the report says, that an organization like the European Union, which creates law that then becomes part of the national law of its 27 member states, that has to count. I think it's right that some international organizations, there may be some in South America, I don't know, where this happens. So to some degree, we should take account of international organizations. Now that was very controversial in the case of customary international law, as you may know, with 2 or 3 states being very strongly opposed to that. But I think in this context, as in that context, it makes sense to allow the work of international organizations, some of them anyway, to count. Now, I've talked far too much. I'd much rather have questions. It's a complicated subject, but my main message is I'd like us to be clear. I'd like to have clarity as to what this subject is. I don't like it when judges, or even academics, if I may say so, throw around lots of terms and say they're all covered by general principles of law. We don't need to find a treaty. We don't need to find state practice and opinio juris. We can just call it a general principle of law, apply it, and it's too bad for states. Thank you.
Okay. Thank you, Mr. Wood. It was a very, very interesting lecture. This is a great problem for us, teachers of international law, because we have to explain to our students this very philosophical topic. I came to my mind some doubts that I would like to put here to our debate. First of them came from the role of International Law Commission.
Yep.
The International Law Commission see differences between jus cogens, and the general principles of law. Would you like to hear all my questions, or?
No, perhaps two, and then I can avoid one of them, and then I'll take the others.
Okay.
Yes, okay, thank you for that one. What about a second one, and then I'll answer one or other.
The general principles of law were the basis to the Nuremberg tribunals and Tokyo tribunals. Don't you think that this new direction for the international law toward to a more codification don't plaster the international law?
Right. Well, I think there is a big difference between jus cogens and general principles of law. They serve a different purpose. General principles of law are one of the three sources of international law in the statute, which I would accept as a complete statement of international law. I would put all the other things like Security Council resolutions, unilateral declarations, I would fit them all into those three sources myself. Jus cogens is about the quality of a rule of international law or the quality of a principle. It has the hierarchical superiority. It can invalidate other rules of international law. So that's a completely different thing. And in the jus cogens topic, we're taking the position that it's a two-stage matter. For example, firstly, you have to determine that there is a rule of customary international law. And then secondly, you have to say this rule meets the requirements for a jus cogens, being non-derogable, etc., etc. So I think they're quite different concepts. Now, I wouldn't say that general principles of law are necessarily going to be jus cogens. They might or they might not. You might have a general principle of law that's eminently can be set aside, that you don't have to apply over all the time. So I don't see a relationship between the two. In the jus cogens topic, we've drafted some conclusions that say jus cogens is principally derived from rules of customary international law. But then we say, but it may be derived from treaty rules set out in treaties. And then we thought maybe derived from general principles of law, but we don't have any examples of this. We're not at all sure about this, so we didn't know whether to include that or not. So even as a basis for jus cogens, there's no practice room, I think. So that's what I would say to your first question. The Nuremberg and the Tokyo tribunals, were they based on general principles of law? They were based on statutes. They were set up by the victorious powers or by law. In the case of the Tokyo tribunals, they applied what was in their statute. The statute set out the rules.
Okay. Brian Kellogg?
Yes, that's a treaty. But I think it was either a treaty applicable as such or it was customary international law by that stage. I don't think it was argued, or it should be argued, that there was a general principle of law that the rules set out in the Kellogg-Briand Pact is international law. I think that's either custom or a treaty. Now, it may be said that some of the Nuremberg principles that they applied, and they did set out principles, and I mentioned one or two of them, like superior orders is not a defense, like the law has to be certain that you can't convict without a prior law, etc., etc. And they set these out, and then the International Law Commission, of course, adopted a set of principles of law, the Nuremberg principles. And it's been argued this week that those principles are general principles of law, because where else did we find them? Well, we actually found them in the judgment of the Nuremberg Tribunal. And we weren't, in fact, deciding that they were general principles of law or even principles of law. We call them the Nuremberg principles. And all we were asked to do by the General Assembly was set out the Nuremberg principles. So we did. We didn't say these are principles of law even. We certainly didn't say they were principles of general principles of law. But it is cited, and it's cited by the Special Rapporteur as one of the examples of an international treaty or instrument, in this case an instrument, a General Assembly resolution or even work of the International Law Commission, that is evidence of a general principle of law at the international level. But I don't think it's a good example. Thank you for your questions.
Okay, thank you for your answers. But, Fernanda, do you have any questions of our academics? Fernanda, please.
You have to unmute.
Yes, no.
Sorry, Professor, they are calling me here. Can you ask me again?
Yes. Do we have any questions of our?
No. No, from YouTube, no.
Okay, Professor, can I ask you something else?
Of course, yes.
Regarding to the problem of legitimacy of international courts that need the consent, in your opinion, the consent should be overcome in terms of the human rights courts. I mean, in terms of international tribunals for crimes against humanity and crimes of genocide, for example, the courts should prevail the consent to install that tribunal.
Well, I don't think, and the International Court has said the same, the fact that something is a rule of a breach of a Jus Cogens rule, like genocide, does not mean that the International Court of Justice has jurisdiction. These are separate questions. In terms of legitimacy, I'm never quite sure what that means, but these courts do have jurisdiction when it's provided for in their statutes, and that's the case for international criminal courts, though one might argue whether they're going beyond their jurisdiction by hunting out people in states that are not parties to their statutes. But generally, I think their jurisdiction, their legitimacy, if you like, is based entirely upon the treaties. The European Court of Human Rights, the Inter-American Court of Human Rights. It works on the basis of a treaty. Now, states may not like the treaty anymore, but they're bound by it until they leave. Above all, states may not like the interpretation placed on the treaty by the court. That's the real problem in Europe. The British government was very unhappy with some of the decisions of the European Court of Human Rights, and thought it was going beyond what had been intended when the European Convention was drafted in 1950. But of course, governments have to realize that treaties are living instruments, as we like to say. And if you set up a court, then you are giving that court the power to reach conclusions. So long as you're bound by the court, you're bound by the decisions you're bound by. I mean, I think that the rejection of the South China Sea award, for example, is unacceptable, even if you disagree with it. And there may be good reasons for disagreeing with it. It may be a very bad decision as regards rocks or something. I don't know. I'm not commenting. But for a state to say we reject the decision of a court when they've agreed to its jurisdiction, of course, they might say they haven't agreed to its jurisdiction, but courts have jurisdiction to determine their jurisdiction, I'm afraid. And that's expressly in the law of the Sea Convention. So, but I'm not talking about any state in particular. I want to make that clear.
Yes, okay. Okay, I understood. Well, I have a last question here about the expression yes. I'm sorry. Civilized nations.
Yes.
This is a big problem for us here because, it is an old expression. I know. I used to say to my students, this statute was sought for people from the 19th century. So the concept of civilized nations are really a big problem. This does not come from a French expression that came from civilization. The definition of civilization from the French.
Yeah.
And so that's the only idea that I came to my mind to explain this expression. And this is a little bit confused for us because of now we are in the 21st century. So why this remain in the statute until now?
Well, I think the reason it remains is that it's very hard to change the statute. If we start changing one provision, we'll open up the whole statute, arguably. I think also it doesn't frankly make any difference. Nobody pays attention to these words. They may sound offensive. They are offensive to modern ears, but they're not doing any harm. We all understand them nowadays to mean all states, and we're not distinguishing between civilized states and uncivilized states. So I think the reason it's not changed is just for practical reasons. You might ask why it was repeated in 1945. Well, I suppose they were only making minimum changes. They wanted to just leave as much continuity as possible. And they'd have probably had arguments about whether to say community of nations or community of states, or the sort of arguments that we're having in the International Law Commission now. But I don't think anyone takes it seriously, but we definitely won't repeat it in any conclusions we put forward to states. We'll allow ourselves to make at least that change to the statute. I wouldn't want us to change principes généraux de droit, however. So I'm rather cautious about changing words in Article 38 of the statute, but that change at least. I think the origin of it, it's nice of you, it's kind of you to blame the French. I don't think it's really the fault of the French, because we do have the word civilization also. In English, we have a Roman heritage too, to some degree. I think it's pure colonialism. You know, in the 19th century, people talked about civilized nations and barbarian nations. You know, there were barbarians. You could do what you liked with tribes in Africa or whatever, and reach all kinds of agreements with them. And this is how international lawyers wrote, some of them anyway, in the 19th century. Now, by 1920, I think that was already changing, but people probably didn't think there was anything wrong with the word civilized, that all states can be civilized. I mean, it has to be said, when you think of things like the Islamic State, you begin to wonder whether there isn't a distinction between civilization and non-civilization. But nevertheless, don't want to go down that road. So I think it's really not a big issue, and it shouldn't be a big issue. And I think you should tell your students it's not a big issue. You know, it's unfortunate, it's there, but it's anachronistic. That's what we said about it. It's good to be there, but it's not doing any harm. It's just a reminder of colonialism. And perhaps it's not bad to be reminded of colonialism. We shouldn't forget about it because it wasn't a great time.
Barbarian, to avoid barbarian.
Yeah. I mean, the Romans distinguish between barbarians and Romans.
Yes.
The way you do.
Mr. Wood, we have 3 other questions here from our guests, and Carol Rodriguez is asking, Mr. Wood, I have a doubt about how the ICJ applies the general principles of law on the case, since until today, the ICJ never decided a case based exclusively on the general principles of law. How are the general principles used as a source of law in practice?
Yes, well, I think that's a very good question, and it makes you wonder, why did the International Law Commission take up this topic? Because is it a topic that arises in practice, or should we have just let sleeping dogs lie? You know, don't raise this difficult issue because it's not an issue in practice. However, the ICJ, I think it's correct. It's very difficult to find an example of the ICJ explicitly applying a general principle of law. Indeed, probably there aren't any. But a lot of people say, for example, in the Corfu Channel case, with the reference to dictates of humanity, and certainly separate judges have referred to general principles of law. The international criminal courts, and I was a bit dismissive of them, but they frequently refer to general principles of law and seek to apply it and explain how they're applying it. And I don't find it terribly convincing, but they do a sort of comparative study. They try to look at the law in a whole range of different legal systems. And so there is something to be learned from what the international criminal courts are doing, even though it is quite a specialized field. But I think the question's a good one because it does raise the question, are we doing more harm than good by discussing general principles of law? One of the effects of the International Law Commission taking up the topic is that more people may write about it and more judges may think about it and use it more often. And this isn't necessarily a good thing in terms of the certainty of international law. On the other hand, I think it is a good thing to try and clarify the law in this field. Domestic judges may often be asked about general principles of law. They may be raised, and how an English judge is going to deal with it is very difficult. On the other hand, if the International Law Commission has said what it thinks in a clear report, then it becomes easier for the judges. I mean, it was partly English judges who said to me they wanted to know about customary international law. How do they decide what is, what isn't? They've got all these arguments. People wave bits of paper at them. and say, look, a rapporteur said this, therefore it's customary law. So that's the reason why I thought it was a good topic. Not so much for international lawyers, but for domestic lawyers who have to apply international law. And the same is even more true with jus cogens. Jus cogens is being raised all the time in the English courts now. And the judges sit there and say, we don't know what it is, we don't know what to do, we look in the books, we don't get any help, the barristers tell us everything. So please, International Law Commission, tell us what jus cogens is. I mean, the Supreme Court judge asked me precisely that 2 or 3 years ago. And I think it's a bit the same with this topic, that it would be useful if we could come up with something clear, relatively rigorous, but also flexible. You know, we're always trying to balance being rigorous with flexibility, because you have to be realistic. So we'll see if we succeed. I think we've had quite a good start with the special rapporteur, as we did with jus cogens. Tulade has been a very good rapporteur. We have a first reading text, and next year we'll do the second reading and finish it. And hopefully that will be a useful thing.
Yes,
that raises the question of the legitimacy of the International Law Commission, which is a very good question. I always say it's a very dangerous place. It's dangerous because other people give it too much weight and too much attention. They say the International Law Commission said this, therefore it's the law. Even as I've said, when they're quoting the wrong documents. And the ICJ also did that. It did it with necessity in the field of state responsibility. It just said, oh, the ILC has adopted this text, so it's the law. Well, that's really bad. It only really becomes the law in the light of what we propose to states, in the light of what states say. So anyone looking at our product ought to look at what states say about it in the Sixth Committee. The trouble is they're often too diplomatic. But occasionally they say, we don't agree, we don't agree, we don't agree. And that's important.
Okay, very nice. Thais is asking, is it possible that ICJ base a sentence exclusively on general principle of law? Are there examples? Well, almost the same question. Yeah.
I mean, I think it's possible that they might. And the Timor-Leste case was a good one. A good example. It was settled, so we'll never know the answer. But Timor-Leste argued very strongly and at length, and the memorial is on the website, for legal professional privilege to be a general principle of law that should apply to lawyers advising in the field of international law, advising governments in connection with, it was advice given in connection with the court case before the International Court of Justice that they took away, the Australian Secret Service. No doubt for very good reason. I'm not complaining, but they took away advice that, not my advice, but advice that Vaughan Lowe and Eddie Lauterpacht had given, because they were taking all the documents from the lawyer's office. But that could have been decided by the court solely on the basis of that it was a general principle of law. And indeed, Judge Greenwood's dissenting opinion against Timor-Leste, but he does have a paragraph in the, I think it was a provisional measures judgment, where he says, you know, we will examine whether legal professional privilege is a general principle of law. And he said that makes it a plausible argument. That's a plausible argument. Well, that's just one judge, and it never was decided. But I think there's no reason in principle why they can't decide on the basis of a general principle of law. They're not just subsidiary, like those in D, like case law and writings, but they may be supplementary in some ways, but that doesn't make them subsidiary.
Okay. Thank you. Thank you. And Beatriz Caldas is asking, Sir Wood, what do you think about the principles established by international criminal tribunals? Maybe those, not the International Criminal Court, maybe those from the Security Council and others systems.
Quite frankly, I'm not a particular specialist in international criminal law, but my understanding is that they have had to take principles from national law to build up their rules of evidence, their rules of procedure, and they're more or less prohibited from looking at customary law. They're supposed to base themselves on the treaties, so they've tended to call them general principles of law, or the other way around in some cases. They've got their own rather rigid rules that aren't necessarily Article 38. If you look at the Rome Statute, it has very strange provisions on applicable law, which include general principles at a certain point. And I think they've made quite wise use of general principles, looking at national criminal legal systems to see how to run a fair trial, which is their job. They should be running a trial that's at least as fair at the international level as the ones at the national level. So my impression is that they've done quite well, except for the only case I was involved in, they did really badly. This was the appeals chamber of the International Criminal Court in the al-Bashir case about the immunity of the head of state of a non-state party.
Yes.
Al-Bashir of Sudan. And it was quite an experience appearing before that court. Mm-hmm. If you read the transcript, it's just amazing. They just kept asking us questions. They asked us questions like, what is your Skogans? Question. Mm-hmm. How long have you got? And they based, I think the way they dealt with that was very poor indeed. And it's not just because I lost, but that really wasn't about general principles of law. I don't think so. It's not really an answer to the question that was put.
Yes, yes. Well, I think it's very, very complicated for us to understand general principles of law, even in the domestic jurisdiction. We are a civil law system, and our tribunals are very resistant to implement or to use general principles of law. We are very based on codes and law and written laws.
Yes. Well, that's good on the whole, because it gets very vague if you start looking at general principles of law. But courts have to when they're applying international law. Insofar as your courts apply international law, they'd have to look at this third source from time to time. And I know there are some quite interesting decisions of the German courts, for example, on general principles of law, which shed some light on it, but not a lot. I think that it would be very good if you could persuade the Brazilian authorities to send in a reply, setting out all their practice in this matter, or even for academic institutions to write articles related perhaps to the reports of the International Law Commission. I mean, they're not very long, but this second report of Marcelo Vázquez Bermudez is very interesting to read. I read it over the weekend to prepare my speech, though I had read it last year when we did. But if you just look at what he's proposing, these last 2 pages, these draft conclusions, which are very short, and try to think whether they're right, whether they could be better expressed. It's a very interesting topic that goes to the heart of sources of international law, and as I said at the beginning, to the certainty of international law. And if international law is not certain, which perhaps some people think it shouldn't be, it brings it into disrepute, and it's going to be even less followed than it is at present.
Yes, this is a very interesting point of view, I think. But in your opinion, don't you think that human rights should be considered general principles of law for the international law and for domestic law?
Yeah, what's the point of doing that? Because in international law, anyway, they're set out in treaties. Okay, not all countries are parties to those treaties, but many are. They're part of customary international law. Large parts of them, of course, precisely what the right to a fair trial involves in the customary international law is not necessarily the same as what the court in Strasbourg or San Jose would say, but nevertheless, they're already really part of part of treaties and customary international law. Now, there was an article quite a few years ago by Zimmer and someone else in the Australian Journal of International Law saying we should stop worrying about whether human rights are customary international law. They should be general principles of law. So it's another way of looking at it, but that hasn't really taken off. And I don't personally think it's helpful or would forward the cause of human rights. I think it's better to say they're customary international law, which is a well accepted source, unlike general principles of law. If somebody says it's a general principle of law, judges are immediately going to be a bit suspicious, saying, what do you mean by that? And how can you say human rights are recognized by civilized nations? On the contrary, I think it's a bit of a diversion to start thinking of them as general principles of law. Now, domestically, that may be a different matter. But domestically, I would hope they will apply the treaties and apply the customary international law on the subject, if need be.
Okay. And the last question for today, in the due process of law, in your opinion, it's a general principle of law, of international law, for the international tribunals in general?
Sorry, what did you say? I missed the first part.
Process of law.
Due process of law. Well, it depends in what context.
Okay.
I mean, I think if you set up a court, particularly a criminal court, then it should be applying due process. If it's a different sort of court, like an investment tribunal, then, they have their own rules. I wouldn't say you can just import due process and say this trumps everything, to use an expression. And I think I certainly wouldn't agree that, for example, the Security Council has to follow due process when it reaches its highly political decisions. So I would hesitate to say due process is a general principle of law that applies across the board, but it may well be something that international criminal courts should be paying attention to and probably do. But it's more when you break it down. What does this mean? It means you have to have proper evidence and all these different aspects of it.
Yes. Well, I think in criminal tribunals where persons are under the judgment, I think it would be a very important principle to be considered.
Yeah.
I have always a difficult, it is very difficult for me to understand in International Court of Justice some principles that would be very, very simple in a domestic way. And this is one of them that it's very complicated because of the characteristics of the International Court of Justice. The legitimacy of the parties and states and states, state against state. This is complicated.
I think the International Court would think it does apply due process. It's very fair to states. And we've seen that particularly with recent cases where a state has not appeared. They have been very careful to try and be fair to both sides. If you look at the Venezuela case, for example. So I think they're really, they do try, but they don't need to say we're applying due process of law. They actually refer to the good administration of justice, don't they?
Yes, yes.
Or things being inherent in being a court. We are a court, therefore we have to do this, we have to do that. But they give people equal time. They're very careful to be fair to both parties. So I think they do apply due process, but they don't need to say it's a general principle of law that we're applying. They just do it because they're a court.
Yes, it's presumed in the statute and so on.
Yeah.
In treaties.
And they built up a practice as well.
Yes. Okay. It was very nice for
Professor, we have a question from Deborah. She raised her hand.
Okay.
Yes, actually, my question relates to what our mediator brought up earlier about the way we use the Institute of, I'm sorry, the word, I missed the word, but the way we use actually in internal law, the way we use as more of general principles of law as more of a ruler against which we measure or other norms, or
right.
When a new law comes in or when a decision is made that is incompatible with a principle of law that we have been accepting of, or that has instituted itself within our constitution, wouldn't that be like a good way of applying the international principles of law within the courts?
You're talking about what happens at the domestic
level. And wouldn't the way that it is applied is more of a ruler against which we stick to measure the new laws or decisions or way of making decisions?
I think that's probably a good point. One of the functions of general principles of law in international law is said to be to help interpret other rules of international law. Now, the Commission hasn't yet looked at this question of what are the functions of general principles of law. That's to be in the report next year. So we haven't thought about it very much, but I said one of the functions was filling gaps, avoiding a non-liquid. But another function is indeed to assist in interpreting other rules of international law, which is perhaps similar to what you've just been suggesting or mentioned at the domestic level.
Yes, we tend to use that as when there is a decision of maybe a new topic or something that is very new and hasn't been yet ruled upon. We tend to use general principles of law, or maybe something that comes from international law and human rights. And human rights is within our constitution. There's an article that states that we have to take human rights as a general sort of a general principle of law to be taken into account when making new decision or new laws. And it is usually something that we use to measure new decisions or new laws to be valid or invalid within our legal. I don't know if I'm expressing myself correctly. I'm sorry.
No, I think, or to declare them valid or invalid, or to interpret them, to make them valid by way of
to verify the application of them.
That all makes sense to me, but I do think by saying that general principles of law you're using, you may be falling into the trap of using this expression in a rather vague way. What exactly do you mean by general principles of law? Are they just what the judge happens to wake up in the morning and think is a good idea? Is there a list of general principles of law somewhere in your?
Yes. Our constitution has something, has a few articles that dictate, that rule what should be taken into consideration.
Interesting. Yeah. But at the international level, there's nothing as clear as that.
Okay, thank you very much.
Thank you.
Okay, Fernanda?
Yes, no more questions.
Okay. Mr. Wood, it was a great pleasure for me to be here again with you, and I hope to see you soon here in Brazil.
I very much hope so too. Look forward to that, and thank you very much for chairing it and staying to the end. Thank you very much. All the very best.
Thank you.
Bye.
Thank you, Dr. Professor.
Bye.
Thank you, sir.
Bye.